Our first panelist is Careen Shannon. She is of Counsel at Fragomen, Bernsen, and Loewy, LLC, which is the world's largest immigration law firm. She's also an adjunct professor of law at Yeshiva University's Benjamin and Cardozo School of Law in New York City, where she currently directs the Immigration Law Field Clinic and teaches an associated seminar. A frequent speaker and writer, Careen has spoken before numerous bar associations, professional organizations, human resources groups, and law schools, and has written countless articles on immigration law topics for a variety of legal and human resources publications. She's also the co-author with Austin T. Fragomen Jr. and Daniel Montalvo of a number of immigration handbooks and treatises published by Thomson Reuters Press. As a member of the study group on immigrant representation founded by Judge Robert A. Katzman of the U.S. Court of Appeals for the Second Circuit, Careen has also been instrumental in bringing to light the lack of quality representation available to indigent immigrants, and has published 2 law review articles on notario fraud and related topics. Careen's a proud graduate of Oberlin College, which was the first coeducational college in America and the first college to admit African American students, and the City University of New York School of Law, CUNY, which is ranked second only to the UDC David A. Clark School of Law for the diversity of its faculty and student body. Our second panelist is Carla Reyes. Carla L. Reyes is an associate in the Perkins Coie Commercial Litigation Group, where her practice emphasizes class action defense. Prior to joining Perkins Coie, Mrs. Reyes served as a public interest fellow to the Volunteer Advocates for Immigrant Justice. She's published various scholarly pieces on immigration law and regularly represents immigrants before the Immigration Court, the Board of Immigration Appeals, and the United States Citizenship and Immigration Services, and also in related state court proceedings. She earned her JD magna cum laude and her LLM in international law in 2009 from Duke University School of Law. She also holds a master's in public policy from the Duke Terry Sanford School of Public Policy. And our third panelist is Maurice Hew, Jr. He is the Director of Clinical Legal Education at the Thurgood Marshall School of Law in Houston, Texas, where he holds the rank of Associate Professor. Professor Hew supervises a wide variety of immigration cases through the student attorneys he works with. Under his supervision, the Thurgood Marshall School of Law was a past recipient of Catholic Charities National Pro Bono Award for Appellate Immigration Litigation. Prior to academia, Professor Hew practiced immigration and nationality law at a Houston boutique firm and was an assistant district attorney in New Orleans, Louisiana. Professor Hew graduated from Loyola University School of Law in New Orleans, is licensed in Louisiana, Texas, and in several federal courts. Professor Hew is a board-certified immigration and nationality expert by the Texas Board of Legal Specialization and serves on the committee which drafts and administers the examination. Professor Hew is a frequent speaker on immigration and nationality issues, and his recent scholarship relates to the application of the Supreme Court's landmark decision, Padilla versus Kentucky. All right, so I'll turn it over to the panel.
Okay, I guess first of all, I want to say thank you to UDC. I've been learning a lot. I guess Mr. Green and Ms. Callender and Ms. Massaro, I guess she's not here, but we're going to have to talk. I'm going to probably have to edit my article. You know, I've learned so much. But you know, I guess the question is you know, why this particular topic? And you know, I was a former prosecutor, and I'm very interested in the criminal immigration issue. We actually call it crimmigration for those who aren't familiar with that particular term. And specifically the plea bargaining. Now, I left the DA's office and went over to an immigration firm. And when I was working in an immigration firm, I actually felt like a garbage man. And you know, I used to take the garbage that used to come from the criminal lawyers, and they used to plead their clients guilty to, I don't know, drug distribution or some type of child sexual abuse. And they say, okay, well, we'll send the case over to Hew and let him figure out an immigration side and let him go win the case. Now, I guess the question is that, how is that possible? I mean, you know, you're giving me your garbage, and I can't win, you know, this particular case. So I guess the question is, in my presentation, I'm kind of limited to more of the criminal context, and you know, I think you definitely have the and should have the right to counsel in immigration proceedings, in some other areas, but I'm going to try to limit a more narrow in scope to for the criminal areas. And you know, I guess, you know, I used to sit there and dream about, you know, well, maybe what would happen if the criminal lawyer would actually call me before the conviction? You know, and the thing is that, you know, they gave me the bad facts originally. So what happens if I get a better set of facts? And I mean, I guess I'm kind of the cockeyed optimist. And then I believe, but look, if you give me a particular type of case, well, maybe I can either find a informed plea decision, okay, where I can win, make an immigration palatable, and also maybe make a plea deal where the prosecutor and the judge will be happy with it, you know, as well. So, and I guess you have to be careful what you wish for, because, you know, those who are familiar with, I guess, the Padilla versus Kentucky decision, you know, in that particular case, the High Court basically advised that the criminal lawyer needs to give pertinent and accurate immigration advice to their particular client. And of course, you know, following Padilla, there's been two huge issues that have come up. You know, one is the retroactivity of Padilla. For those who are following Padilla, of course, you should know that the High Court just about dead in that issue. And in that particular issue, they said Padilla wasn't retroactive on the federal level. And unfortunately, about 8 days ago, Texas, home state, now just followed and said Padilla is not retroactive, after they had previously said that it was. Now, I guess the other issue that individuals have been fighting with on the Padilla issue is prejudice. And, you know, if you remember from Padilla, for those who've actually read Padilla, the High Court actually looked at only the attorney performance problem. They didn't look at the issue of prejudice. They actually said, well, we're going to remand the case back down to the Kentucky Supreme Court, let them figure out whether Padilla was actually prejudiced or not. Okay? Now, so prejudice actually is the issue, and I guess the question is what is prejudice? And I think what we need to tell ourselves is that it's whether there's just been simply a fundamentally fair trial. Was it fair? Was the conviction accurate? Is the conviction something that's valid? Is the conviction, you know, reliable? Can we rely on it? It's not the issue of whether the individual is actually guilty or innocent at the end. Okay? And I guess I'm also writing on this because of course, the law review. And I wanted to make sure we also understood that the Sixth Amendment, you know, the civil Gideon, is it requires at least 3 different areas, and not just one. And I think, you know, we've been talking a lot about the availability of counsel, you know, giving free appointed counsel in the immigration back end. And we've been touching on a little bit about, well, if we give individuals counsel, that counsel also has to be effective. We just can't give them what I guess Mark had indicated last night. We just can't give them a potted plant, right? We got to give them, you know, counsel that's going to be effective. And then lastly, I mean, what's the role of the right to counsel in the overall proceeding? Okay. So I want to more focus on the effectiveness of the counsel. And I think someone had asked a particular question earlier. You know, how do we make this particular counsel effective? And I guess I'm taking the position, well, if I can make the criminal lawyer effective, at least immigration effective in the front end, which is what the constitutional mandate is. Now, make no mistake about it. Padilla was decided in 2010. It's not retroactive, but from 2010 toward the forward, Padilla is in play. Okay, so then the question becomes, how do we make that criminal lawyer more effective such that we're going to have 2 bookend results? In the immigration side, we're either going to have one where he's not deportable at all. So we don't even need the proceedings or an immigration lawyer in the back end. Okay, so he's going to plead guilty to someone who is not going to be deportable, or we're going to have a plea where the individual will absolutely be deportable. But when they actually are deported, or when they actually plead guilty, I should say, the plea is going to be knowingly and voluntarily and intelligently made such that the individual knows that they're going to be deportable. And then they're not going to have to sit in the immigration jail for 504 days, which is the average time to actually handle the immigration proceedings. Okay, so this is your mandatory detention in the back. So hopefully this is a more practical approach, more judicial economy. We're going to forget about the prolonged detention in the back end. Let's figure out what the constitutional mandate is now, use what we have now, and let's get it done correctly. So when we look at that issue of prejudice, a lot of individuals are basically familiar with Strickland. but I don't know if anyone's been talking about presumed prejudice. Now, Strickland actually had a twin, and on the same day that the Supreme Court decided Strickland, they actually decided a case called U.S. v. Chronic. Now, Strickland, of course, is known for the two performance, well, the test, right? First test is performance. Second is that we have to prove prejudice. Prove prejudice affirmatively, right? But Chronic and Strickland also talk about there are situations where prejudice should be presumed. And they took about 6 or 7 different scenarios where prejudice should be presumed. And what I did in my paper is that I took those particular illustrations, took a post-Padilla world, and said, well, maybe in these situations, instead of the lawyer trying to prove prejudice affirmatively to overcome the convictions, maybe prejudice should be presumed, okay, such that maybe the conviction should be overturned, such that, once again, we don't need the removal proceedings or the immigration lawyer in the back end, because the constitutional mandate is for the criminal lawyers to get it right in the front end. And the criminal lawyers are the front line now. They're on the front line of immigration removal defense. The immigration lawyer in the back end is not the front line, because the immigration lawyer in the back end can't do anything with the case. Because you already created the facts for me, and I can't win it. So if I change the facts in the front, that's what we're going to do. So I can win the back end too, right? Or avoid the back end completely. All right? Now, the first scenario that Chronic and Strickland actually talk about is the actual denial of counsel. And we all know that, okay, yeah, if you're not provided with counsel, well then, that's what we've been saying all along, it's not fair. But we should know that the Sixth Amendment also provides that the right to counsel doesn't always attach. And it doesn't attach in criminal cases, basically when there's misdemeanors, and imprisonment is not necessarily imposed. So just to give you an example, in Texas, we actually have a crime, possession of drug paraphernalia. Possession of drug paraphernalia is a Class C misdemeanor. It's punishable by a $500 fine at the maximum, okay? And there's no jail time. So the Justice of the Peace courts actually handle those cases in Texas, and because there's no jail time based on the Texas state statute, there's no counsel appointed in the Sixth Amendment criminal case. And then, of course, the Justice of the Peace in Texas don't have to have a law license, okay? And I actually went to the Justice of the Peace and tried to talk to him about Fifth and Sixth Amendment due process right to counsel, and he didn't know what I was talking about. But where I'm getting at this point is that where we don't, in some of those, I guess, who are practicing immigration law are familiar with this, is that drug paraphernalia is a deportable offense. So you go and plead guilty to a Class C drug paraphernalia in a misdemeanor court in Texas. Judge is going to tell you you're going to get a $500 fine, maximum. You don't get counsel. You plead guilty to it, and then you turn around and sit in an immigration jail for 504 days. So this is due process, liberty interests at stake. I think back to the presumed prejudice, this is actual denial of counsel. And I think those particular cases should be actually overturned, the conviction right off the bat, because we don't have counsel there, and you got liberty interests at stake in the back end. Okay? Now, what could he have done? Could he have done something different? Of course. Instead of pleading guilty to the pipe, plead guilty to the pot. To plead guilty to the pot less than 30 grams of marijuana, if marijuana is less than 30 grams, well, you're not deportable. Right? But if you plead guilty to the pipe, then you are. Now, I guess if you had effective counsel, hopefully the criminal lawyer would know that. And say, well, look, prosecutor, even though he's charged with possession of drug paraphernalia, well, let me plead guilty to the pipe and let's dismiss the pipe. Okay? So I took that position as, actual denial of counsel, presumptive prejudice. We talked a little bit about what we like to refer to as the constructive denial of counsel. Now, I guess probably the most famous case of constructive denial of counsel is the Bernsen versus Johnson case, and this is where counsel's actually sleeping. The counsel's 70 years old and he's sleeping during the middle of his client's life-death sentencing phase. And it's actually kind of funny because, well, maybe he thought it was funny, but they actually interviewed the attorney and says, well, why were you sleeping during the middle of your client's sentencing phase? He's going to get death or life. Why were you sleeping? He's like, well, I'm 70 years old. I need a nap in the afternoon. And basically that's what the lawyer had advised. But, the court actually said, well, this is a constructive denial of counsel. If the lawyer's intoxicated, if the lawyer's drunk, if the lawyer's sleeping, this is presumptive prejudice. Now, one of the other issues that Padilla had talked about was affirmative misadvice. But Padilla also talked about an omission. What happens if the lawyer remains mute or fails to advise of the immigration consequences of this particular plea? Okay? Well, the court basically said that muteness as well as affirmative misadvice is equally constitutionally deficient. Okay, so, well, is the failure to give immigration advice by the criminal counsel constructive denial of counsel? Now, I guess the thing is that we'd all say, well, yeah, the court looking at it from the back end would look at, well, let's look at the tactics or let's look at the strategy. If the criminal lawyer failed to do something, well, we're not going to say, well, there's a checklist and says, well, he's going to be ineffective for every single thing, right? The courts are going to give the criminal lawyer utmost discretion on how to represent their client. But then the question becomes is that if the criminal lawyer fails to give immigration advice, what purpose does it serve? It's not tactical. It's not in the best interest of the client. It's just something the lawyer failed to do. So is that a constructive denial of counsel? Now, the third scenario that Chronic and Strickland actually talk about is state interference when counsel. So if the prosecution actually interferes with the representation of the attorney and the client, that's presumptive prejudice. Where the defense counsel also fails to adversarially test the prosecution's case, that's presumptive prejudice as well. Now, in Texas, and those of you familiar with the prosecutions along the border, the government has actually instituted what they call fast-track jurisdictions. Fast-track prosecutions. There's just too many illegal reentry after deportation cases. There's too many alien transportation cases. So these are set for fast-track. Before the individual actually walks into the courtroom, the deal's on the table. You plead guilty to this, waive Fifth Amendment, waive Sixth Amendment, waive your indictment, waive all your appeals, and you get a 4-level downward in departure. But what's happening, and the government knows about this, is that they have 4,000, right? Small number, huge number. 4,000 U.S. citizens being deported on an annual basis. And the U.S. government is actually settling these particular types of cases. Now, to give you an example of a fast-track jurisdiction case that we actually had coming through Texas is a case called U.S. versus Juarez. Now, Juarez actually acquired his United States citizenship through his mother, derivatively. I like to refer to as by accident. He didn't have to do anything to acquire U.S. citizenship because it's all his mother's doing. Okay? He was a criminal, no doubt about it. Pled guilty in Texas to crimes. Government puts him in removal proceedings. U.S. citizen, mindful, right? Puts him in removal proceedings. Orders him deported. Puts him in immigration jail, 504 days. Order you deported, if he's a citizen. Drops him back off in Mexico. Like criminals, sneaks across the back border. Applies for a gun permit. Has the intention to lie on the ATF application. I'm really a citizen, I'm entitled to a gun. But he doesn't know he's a citizen, right? So he actually has the intent to lie. And the government picks it up on the ATF and says, well, wait a minute. You pled guilty to, you were previously deported, you're not a citizen. So they charge him, okay, with lying on an ATF application, and illegal reentry after deportation. So then they put him in a criminal court with a prosecutor and with a criminal defense lawyer, fast-track jurisdiction, plead guilty. Sitting in a federal jail, wait a minute, I was a U.S. citizen. Maybe I shouldn't have been deported 12 years ago. Maybe I shouldn't be sitting in all these jails. I'm a U.S. citizen. This is an affirmative defense to these criminal convictions. So he files a petition and he goes to the magistrate, tells the magistrate, I'm a U.S. citizen. This is an affirmative defense to these criminal convictions. And you know what the magistrate says? You didn't prove prejudice affirmatively. Now wait a minute, he can't be found guilty, but you proved to me that your lawyer was ineffective and what he did was a harmless error. So then the magistrate sends it to the district court. And the district court says, I'm going to stamp what the magistrate did. You couldn't prove prejudice to me affirmatively. Goes up to the circuit court. Fifth Circuit finally partially gets it right and says, your lawyer was ineffective. And the reason why your lawyer was ineffective was because your lawyer didn't investigate the citizenship claim, but didn't fault the prosecutor or the court and say, well, what about this fast-track jurisdiction? You're running these cases through the court system at the speed of light. We waive in all these particular rights, but who instigated that? And then I guess the question is this, is that when the deal is on the table, how long does the defense counsel actually have to do a citizenship claim alienage investigation? Oh, I have this one of 4,000 erroneous deportation orders that are issued annually. And this is what the U.S. attorney is relying on. And maybe, I guess, maybe I'll give you discovery, and here it is. And the defense counsel is going to rely on that as well. This is not affirmative prejudice, this is presumptive prejudice, okay? And, of course, we get into conflicts of interest. And, following Padilla, we have, pre-Padilla, the lawyers are trying to limit their scope of representation. I don't do immigration, I only do criminal. Okay, so maybe you go hire an immigration lawyer. This is pre-Padilla. And of course, the lawyers are also basically saying, well, maybe I'll remain mute, or I won't say anything at all, pre-Padilla. But now the constitutional mandate is that you have to give accurate, correct advice. You can't remain mute. And I don't know what criminal lawyers can now honestly tell themselves, well, I'm going to limit the scope of my representation after Padilla to exclude immigration and only do criminal. I think, when Strickland and Chronic talks about the materially limiting relationship when there's a conflict of interest between the lawyer and between the client, there's an example of it. Okay. Now, I had a little difficulty, I guess, in the last one. In the last scenario, they had talked about the polity Alabama situation. This is a situation where circumstances are of such magnitude. The circumstances are so great that not even a competent lawyer can actually represent the client effectively. Okay. I actually took the position, well, I think the criminal procedural statutes that are requiring criminal courts to give individuals immigration admonishments during the colloquy. And the federal courts are now, under Federal Rule 11, they don't have this requirement. But recently, the Judicial Conference actually approved, and it's actually sitting on the Supreme Court, as to whether or not we want to make the federal judges basically give immigration advice. Now, I've taken the position that I think, following the polity Alabama, I think these are circumstances, or these are factual scenarios that a competent lawyer can't represent their client. Now the scenario is this, is that when the lawyer is there, standing next to the client, and the individual is basically pleading guilty, the judge is basically giving immigration advice. Now after Padilla, why should the judge be giving immigration advice? Because it's the lawyer's job. What happens when the advice actually conflicts? What happens if the lawyer basically tells the client, you're not going to be deported for this particular offense? But what happens if the judge gives the boilerplate language and says, well, you are? Now, what's the client supposed to do? Is it supposed to follow the judge? Is it supposed to follow the lawyer? Now, what also happens is this, is that if you look at the proposal to the Federal Rule 11, the federal judges are supposed to be asking what the immigration status is of the individual. Well, I think the thing is that in that scenario, if I was counsel, I'd be saying, based on the Fifth Amendment, you have a right against self-incrimination, and I'm going to tell you not to answer the judge's question. Because what happens if you have this individual there and says on the record, oh yes, I'm not a citizen? Well, we're going to have it on recording, and they're going to take that evidence and put it in the immigration backend, such that your client is admitting they're subject to deportation. I think this is going to be your factual scenario where the interplay between the lawyer and the judge, okay, is going to be some circumstances in which even the competent lawyer can't control and can't fix. Okay. And then, of course, I'm going to conclude at the end is that the door to the right to counsel on the civil immigration backside has been unknowingly opened at the government's expense in the front end, because it's the criminal mandate, and the criminal attorneys have an obligation now to advise of immigration. And if they can resolve it in the front end, then we won't have to worry about the back end. Okay. Hopefully I didn't go over.
Okay, so a few preliminary remarks before I dig into the substance of my paper. First, as noted, I am a commercial litigator, generally speaking, with Perkins, Coie in Seattle, but I am heavily involved in pro bono representation, immigration matters, and generally speaking, I focus my representation on issues involving unaccompanied minors. That's just sort of been my subset specialty, in part because I'm in Washington and there's a very high need there because of detention facilities and such. In addition, as I'm just pursue advocacy of immigration matters generally from a personal perspective, and part of that is research and writing on my own time in this field. So that's what brings me to you. A couple other preliminary remarks. One is that my paper specifically it talks about expanding access to counsel for immigrants generally, not just detained immigrants, but immigrants in removal proceedings generally. So it does kind of bracket off USCIS a bit before the agency, but I don't want to look just at detained immigrants because the need is greater than that. And additionally, my paper does not allow the discussion to bracket off issues of funding. It has pursued a methodology which requires us to consider where the funding would come from. Because if we don't do that, we're never going to get anywhere, and the clients are not going to get the actual help they need, no matter how much I theorize about it in my paper. So in addition to these preliminary things, you should also know that at heart, at core, I'm an interdisciplinarian. My training comes from various fields, and I have therefore approached this issue from an interdisciplinary perspective, incorporating legal, historical, and policy considerations into a systemic and methodological approach to evaluating proposed solutions that are already out there in the literature from the legal field. I specifically looked at 3 proposed solutions to expanding access to counsel in the literature. Substantively, I would love to add this non-lawyer proposal to that analysis, because I'm curious where my methodology would net me out if I add that to the mix. But Additionally, I've bracketed out the way to implement those, that substance, because I don't think we can just assume that it's going to happen through the judiciary. It hasn't. For a very long time, it hasn't. For a variety of reasons that we've already talked about, the civil-criminal divide, et cetera, et cetera. So the paper takes two parts. One, looking at substantive proposals and evaluating them from a methodological policy perspective, and second, doing the same for the implementation of those substantive proposals. Ultimately, I net out at, and we'll get into this a little bit more in a bit, but I net out at recommending that advocates explore a court-appointed special advocate type program for immigrants in removal proceedings. Not that the CASA advocate would represent them in removal proceedings, like as their lawyer, as this non-lawyer idea that we talked about earlier, but rather that they would be able to address, the idea is they'd be able to address a variety of other obstacles that immigrants in removal proceedings face to fair process, even though they're not, it has nothing to do with whether they have a lawyer or not. And those are some of the things we're going to explore right now. So I start with looking at the history of immigration policy and its connection to jurisprudence. Notably, I go all the way back to the founding. I mean, because and it has gone in a cycle of openness and restriction, and interestingly, some of the more restrictive judicial policies that we've been discussing here, most notably perhaps the civil-criminal divide, was initially pronounced during a period of restrictive policy at the congressional level, right? So my argument is subtly, I admit I don't come right out and say it because it's sort of against our, our jurisprudential core, but the idea being that the judiciary and the legislature, the actual policy focus isn't always as divorced as we'd like to pretend that it is, and that those policy factors are going to bleed into the jurisprudence, and that given that and looking at the present state of things in the policy sphere on the immigration debate, I don't think it's likely that we're going to gain much jurisprudential ground anytime soon, especially if you look at recent decisions like Padilla. The comments of the court that get everybody all excited, like maybe we're going to make some ground here on this civil-criminal divide, is all dicta. If they really wanted to advance the ball further, it wouldn't have been dicta, and we'd have a decision that narrows the gap between the civil and criminal divide. But we don't. So with that said, that is the approach or the background I had as I approached the paper. Additionally, I explore, as I said, what I'm calling sort of non-legal obstacles that immigrants face. So things like culture, language, the idea that I can be representing one of my youth in their native language is Spanish, and I speak Spanish, and I can communicate with them in Spanish, and when they're on the stand, I ask a question in English, and I understand their answer in Spanish, and the interpreter, although they have a right to an interpreter, gets it wrong. And I object, and I get in trouble for objecting. Like, let's be honest, it annoys the court, because the interpreter, I mean, it annoys the court. The interpreter is there to officially interpret, and they've been certified and yada yada, and the assumption is that they're going to use the right interpretation, and it's not, it's wrong. And my record gets all messed up. And when I object, then that only further serves to mess up the record because I get instructions from the judge, don't object on these grounds, etc., etc. So that's one. The other is the idea that's been discussed in literature that in other cultures, for example, not looking someone in the eye when you're testifying, when you're speaking with them is a sign of respect, but for the judge, it's an issue of credibility. And these issues of credibility have come into play, with the changes in immigration law in the 1990s, and it's just more difficult for an attorney even to sort of insert themselves effectively in those non-legal barriers to fair process in removal proceedings. So with that history and those other non-legal barriers to removal proceedings in mind, I scoured the literature for proposals to expanding access to counsel. So I note, as a caveat, that I didn't assume that the answer is a right to appointed counsel, right? That's one of the policy alternatives that I considered because it is clearly most written about proposal in the literature, right? The other two that I considered in the paper are, it was mentioned earlier, the legal orientation program. There's been a proposal to, so currently it's focused only on detained immigrants, and it covers certain facilities. The intent is that it covered all the facilities, and for a time it did, but facilities grow and the funding didn't. So even now, not all of the detained immigrants are able to receive or to participate in the legal orientation program. And just a reminder, if you missed the earlier description of the legal orientation program, it's like a know your rights presentation. You know, in Tacoma, for example, in our detention center, local nonprofit, the Northwest Immigrants' Rights Project, receives funding for this. They go to the Tacoma Detention Center and make Know Your Rights presentations. And unfortunately, part of the, it's funded through EOIR, and part of the restrictions on the funding is that you don't actually provide legal advice, right? So no analysis of the case. It's not a screening, it's a Know Your Rights presentation. So there are limits. But there's a proposal in the literature that every immigrant in a removal proceeding participate in the LOP, not just those in detained proceedings and not just those detained at certain facilities, which is where it's limited now. So that was the second proposal that I considered. And the third was this CASA type program, which is currently underway for a subset of folks in removal proceedings, namely unaccompanied minors, which is appropriate rates CASA program for unaccompanied minors in Illinois, Iowa, in the Midwest. And it's been working very well in that subset of, for that subset. And so the proposal in the literature is to consider expanding that type of program. And as I mentioned, the idea isn't that these folks would represent the immigrant in the proceedings, but namely that they would help them navigate all those non-legal barriers, that they would help them find an interpreter, and this would especially be for before USCIS, where you get to bring your own. We have to bring your own interpreter unless you're in an asylum interview. But that you'd be able to work to make sure that that client is effectively understood by the court, by their attorney, if the attorney doesn't speak their language. That the idea being that CASA person could connect the immigrant to an attorney in the first instance, namely, in the tax court panel, they talked about the notice, the stuffer that they get, there's a clinic available. So that happens in immigration proceedings as well. You get a sheet that says, in Seattle and Tacoma, there are these folks who might be able to help you on a pro bono basis. But I mean, unless we come to the Tacoma Immigration Detention Center, it's unlikely they're going to be able to reach out to us, right? And so the idea being that whether detained or not detained, this CASA person might be able to provide an avenue to reach out to counsel. If they can afford counsel, then maybe the CASA person can help them evaluate whether they're good ones to pay for or not. So that's the idea of the proposal, right? Without getting too bogged down in methodology, I borrowed a methodology from the policy analysis sphere. Namely, I also scoured literature for what we call criteria to weigh the alternatives against. A few of the more important ones, it turns out, is that it'd be politically feasible, so this gets to the funding issue, that the policy alternative would be politically feasible, and that it would respect due process, so this idea of promoting actually getting fair process, and then that the procedure would meet accountability, namely that if the substance of the alternative wasn't actually provided to the immigrant, that they'd have a way to redress that fault, that that it would be appealable, that it would be enforceable, essentially. And then as to the method of implementation, I looked at 4 methods of implementation, namely memos or guidelines issued by DHS and or the chief judge, which there are numerous of them circulating on prosecutorial discretion and how to treat minors and testimony by minors and immigration proceedings, et cetera, et cetera. Problem is, the criteria where it fails, not accountable. There's no measure of accountability. You can't enforce those. It says right in the memo, not enforceable. This does you no good unless we want it to. The second method I looked at was impact litigation. As I've already stated, for a variety of reasons, it failed the criteria because it's unlikely to happen. It goes a little bit to political feasibility, although that's different, obviously, in judicial context, but the same idea that it follows the general prescriptions of the policy sphere as well. And then I looked at regulatory change and statutory change. On the key between the two of those was the political feasibility issue. Otherwise, I'd say statutory change is probably, I mean, it is ideal. It's the most enforceable, it's the most likely to reach everybody, and it ostensibly goes through, I say that with a smile because we know better, right? But it's supposed to go through this creative deliberation where there's debate and it's thoughtful and you create the statute, et cetera, right? Clearly, I'm not an idealist. But where I net out is that in the current state of things, getting immigration reform generally through, and in particular, a right to counsel through Congress is highly not politically feasible. Rather, regulatory change where advocates lobby DHS, and they've done this before, and it gains some traction, but where advocates lobby DHS to issue new rules through rulemaking procedures, so you still get period of comment, notice and comment. There's a little, and you can to a certain degree enforce regulations. Then that's where I netted out. So ultimately, I netted out on recommending a CASA-type program implemented through regulatory change, because I think that a CASA-type program can happen through volunteers. No need to fund it. Yay, politically feasible. And it can happen through volunteers of any kind. It doesn't have to be a law student, right? It's CASA. It could be it could be social workers, it could be social work students in social worker school. It could be undergrads, whoever could go through the training and provide all the additional help to navigate the non-substantive barriers to fair process. Now, admittedly, I do not offer this or even recommend this solution as the best, ideal, or stopping point solution. It's an interim policy alternative designed to get us somewhere, to advance the ball, because there are clients sitting in detention right now who need help now, and there's no funding now for anybody else. So the idea being that this would be sort of an interim step that doesn't replace lawyers, doesn't and it could stay in place even after the judge decided that you had a right to counsel, say, or the Congress passed a right to counsel. There could still be a need for a CASA person to advance the case, to look out for the best interest of the immigrant as opposed to their stated interest, or what the perhaps ineffective counsel says is their stated interest. Someone to put outside pressure. From this process of looking at policy alternatives, I can extrapolate a few lessons from the idea of access to counsel in removal proceedings to the access of counsel generally. Namely, the mere presence of counsel does not obviate all obstacles, right? They're the same obstacles that I mentioned for immigrants in removal proceedings face indigent clients in all civil cases, right? Especially, and this is in part, it in my jurisdiction. We have a very, very diverse population in Seattle, and the need for interpreters, for example, of every language is so great, and if you can't be understood in your language in any civil proceeding, that's a barrier to fair process, no matter who's sitting next to you, right? It could be justice of the Supreme Court themselves. If you can't make yourself understood, you're not going to get fair process. The second is just this idea that the jurisprudential and political history of a certain type of proceeding is linked. I think that that's true across types of civil proceedings, not just for immigration policy and jurisprudence. And the idea being that if we want to advance the ball for indigent people in civil proceedings generally, we're going to have to be aware, whether we want to be or not, as attorneys, of the political climate we find ourselves, both at the state level and the federal level. Especially with the funding issue. I know we like to bracket it for our discussions, but I just like practical level, we can't just bracket it. And then lastly, just the idea that in order to make meaningful change for people on the ground, as you know, in the immediate future, we may have to look beyond sort of judicial solutions and even the normal statutory solutions, because there just may not be the will to, on either the judicial side or legislative side, to make that happen. And so the paper is intended, as I said, not to suggest the optimum outcome and the end outcome, but to sort of encourage scholarship on the issue, much like what we heard earlier, to pursue creative solutions, to think about how we can benefit folks now and not 50 years from now, when we may get another Padilla decision that may advance or not the ball further for the clients. So that's the piece.
Okay, thank you. I want to thank everybody, first of all, who worked so hard to put this together. Robert, Stacy, Megan, Professor Campbell, thank you. Shout out to UDC, David A. Clark School of Law. When I was applying to law school in the 80s, so a long time ago, I was looking for a school like this, activist school with clinical education. I actually applied to exactly 3 law schools: Northeastern, CUNY, and Antioch. And when I came to visit Antioch, more than one person said, well, you know, we might not be around for much longer. And I'd heard similar things when I visited Antioch College as an undergraduate, so I thought I'd better listen to them. Of course, it was true. Next year, Antioch disappeared as an institution, but it's here again, and it's fantastic. As a CUNY law grad, I'm right with you with the kind of work that you're doing here. The title of my article and my presentation is "Immigration is Different: Why Congress Should Create a Statutory Civil Rights Council in Immigration Matters." But Carla's probably right, we're not going to see statutory change, so thank you very much. And actually, I think I should change the title to "Why Congress Should Create a Statutory Right to Appointed Counsel in Immigration Proceedings," because there actually already is a statutory right to counsel in immigration proceedings. Well, they don't call it a right, they call it a privilege, so you have a privilege to be represented in immigration proceedings at no expense to the government, as you've heard before, so it's only if you can afford it yourself, or you can find one of those rare pro bono attorneys or BIA accredited representatives to represent you that you can get representation at all. So it's a privilege. It can't cost the government anything. Oh, and it doesn't have to be an attorney. That's already there in the law. But I wanted to just give some context and some facts to everything that we've heard over the last few hours about why this is such an important issue in immigration. Immigration really is different. It really is much more like the criminal justice system than the civil justice system. There's also a whole other aspect of immigration adjudications that we haven't even talked about today, which is that most people who are encountering the government in some way to do with immigration aren't in immigration court. They're dealing with the Department of Homeland Security and 3 separate agencies within DHS that adjudicate immigration benefits applications of one kind or another. So I'm going to talk a little bit about that. I also think it's just this is a really important time to be talking about this, because it is looking like we may have some kind of immigration reform on the horizon. And if we're going to have millions of undocumented immigrants coming forward applying for legal status, that is ripe for disaster, for fraud by the notarios and the immigration consultants and the unscrupulous attorneys, for that matter as well, who take advantage of this vulnerable population. So ideally, I'd like to see this addressed in some way in whatever comprehensive immigration legislation we may see. I absolutely agree, and I don't think anybody would disagree, that detained immigrants in removal proceedings, they really need to have counsel. Not even getting into the whole constitutional analysis. I mean, mine is more of a policy argument and a justice argument. But the stakes are so high. The stakes can be higher than in the criminal justice system. We're talking about deportation, after all. We're talking about banishment and exile. Sounds like something out of the Middle Ages, right? But I mean, you're often tearing people away from their families, some of whom may be U.S. citizens, U.S. citizen spouses or children. The removal system under U.S. law lacks just about all of the procedural safeguards that we rely on and value in the U.S. justice system. Just briefly, no Miranda warnings, no right to a speedy trial. People can be subject to mandatory detention, sometimes for years, without the opportunity for a bond hearing. Many non-citizens agree to deportation, voluntary departure, as they call it, very voluntary, right? It's really the equivalent, the immigration equivalent of a plea bargain, without ever appearing before a judge. There's no prohibition on the retroactive application of the government's removal power on lawfully present immigrants based on old criminal convictions that would not have made them removable at the time the offense occurred. There's no statute of limitations on the various grounds of deportability. There's a grossly inadequate discovery process. The respondent can be compelled to testify, regardless of their mental capacity, their language skills, their general competence. And if a respondent seeks to invoke the Fifth Amendment right against self-incrimination in immigration proceedings, the immigration judge can draw an adverse inference against that decision. People are often removed without even knowing it. They're subject to in absentia removal orders. And even when they're afforded a hearing, we talked before about the Article 3 court versus Article 1 court situation. People find themselves in immigration courts which are part of a government agency, they're part of the Department of Justice, and I think that their judicial independence is not self-evident given that fact. So immigration is really different in that way. It's also different because of the staggering number of people that are being deported under our current system. President Obama, I love our president. I love that he's finally taking the lead in pushing immigration reform. But I also am critical of how he got to where he is now, because he spent the first 4 years of his administration increasing the number of deportations beyond anything we've seen before. And that was obviously part of the political calculus. Then Congress can't criticize him for not having done everything he can to close the borders and ensure border security and all of that. But in 2012, the United States deported more than 400,000 people. That's a record. That's a historical record. The deportations under the Obama administration are on track to hit 2 million by the end of this year. That is nearly the same number of deportations that occurred between 1892 and 1997. So over a century's worth of deportations could occur within the first 5 years of the Obama administration. This program that you may know of called Secure Communities, which is a federal program that partners, Department of Homeland Security partners with local law enforcement to identify and arrest and remove so-called criminal aliens. It's supposed to focus on hardcore criminal aliens. I hate that word, but that's in the statute. It's really led, though, to the mass removal of low-level offenders, of just random non-citizens that are picked up in raids, of many people with U.S. citizen family members, and it's had a disproportionate impact on the Latino population in particular, with Latinos comprising 93% of individuals arrested, though they only constitute approximately 77% of the undocumented population. Immigration is also different because we have a large, the largest civil detention system under the jurisdiction of the Department of Homeland Security, U.S. Immigration and Customs Enforcement. The last numbers I could find were for 2011. There were approximately 429,000 immigrants detained over the course of the year. It's a huge number. And these people are held variously in ICE-owned facilities, but they're often put in regular prison facilities because that's where there's bed space. They're incarcerated with hardened criminals. They're also quite often housed in profit-making detention facilities. And no coincidence, and I think you've done some work in looking at the state laws. Some of the state laws, such as the law in Arizona, many of the lobbyists that were behind the drafting of that law were profit-making detention facility companies who thought that if we create these state-level laws that both focus on rounding up the undocumented people in our jurisdiction, and also, by the way, create all sorts of other new felonies that make it almost guarantee that more people are going to be arrested and incarcerated. Guess who makes money? The for-profit detention facilities. I remember when I was younger, I would read these Amnesty International reports about human rights abuses around the world. I didn't realize that they also wrote reports about the United States, and they do. One in particular recently was called, I think I have it here, Jail Without Justice. They documented abysmal conditions in the detention facilities in which immigrants are held. And you may have seen in the New York Times, I think, Robert, you sent a link around too, from just last week. The New York Times published an article based on federal data that they had gathered that showed a shocking number of people held in solitary confinement in immigration detention facilities. And remember, these people are being held in detention not because they've committed a crime or they have already committed a crime and served time elsewhere, but they're being held just so they'll show up for the removal hearing, right? And yet sometimes some of the stories in the article are particularly shocking. Somebody who refused to go to the dining hall because it was Ramadan and he was fasting, and he was punished and put in solitary confinement. Terrible, terrible stuff. Interestingly enough, in the face of the budget sequester earlier this year, I suddenly released about 2,000 detainees, which begs the question, why were they detained in the first place if suddenly it was felt that they didn't need to be detained? You know, so it's just kind of this crazy Alice in Wonderland system that we're really talking about. Erin addressed this a little bit in her presentation, that immigrants with counsel are overwhelmingly more likely to prevail in removal proceedings than are those without counsel. There was a pioneering study in New York under the auspices of Judge Katzmann's study group on immigrant representation that did, we all knew this intuitively, but somebody has to gather the empirical data so that we can get policymakers to act on it. So they gathered the empirical data, they looked at removals in New York over a 5-year period from 2005 to 2010, and they found that immigrants with representation were 500% more likely to win their cases than were immigrants without. So, you know, I mean, contrary to popular belief, just because you're detained or just because you're put in removal proceedings, it doesn't mean you don't have a claim to stay here. You may very well have a claim. You may have a claim to what they call cancellation of removal. You may qualify for asylum or some other kind of humanitarian relief. You may have a family member who can sponsor you. You may have an employee. I mean, there are lots of ways that people can actually mount a defense to a charge of removal. If you don't have a lawyer, you're not necessarily going to know that. And that statistic, 500 times more likely to prevail with a lawyer than without, I mean, that tells it all. So we've heard about possible non-lawyer models of representation, and we already do have a system, you know, under the immigration laws for BIA, Board of Immigration Appeals, accredited representatives to represent people in immigration proceedings. What is often not looked at, and this is going to be much of the focus of my article, is the fact that, as I mentioned at the outset, significantly more people are encountering the immigration system and immigration laws outside of immigration court. They're applying for visas, they're applying for green cards, they're applying for asylum, and that doesn't happen in court with some exceptions. That is an affirmative application that you would make to one of the 3 agencies under the Department of Homeland Security. If you don't have counsel or some kind of representation, there's no way you're going to even know who these agencies are, where you go, how you apply. Pre-9/11, we had the Immigration and Naturalization Service under the Department of Justice. Then, post-9/11, Homeland Security became the thing, right? So then they broke up the old Immigration and Naturalization Service, they put it in DHS, they created 3 separate agencies, which is something that people have been talking about for a while, because there was always this notion that one agency can't both be a benefits granting agency and an enforcement agency without there being some serious cognitive dissonance within the agency, and I think that's still the case, because I think there's still an enforcement mentality even among the benefits granting part of the Department of Homeland Security. We have 3 separate agencies with 3 separate mandates. U.S. Citizenship and Immigration Services, where you apply for what they call immigration benefits. That doesn't mean like a cash-based benefits. It means a visa or a green card. U.S. Customs and Border Protection. That's the Border Patrol guys on the Mexican border, the people in the airport when you fly in from abroad. And U.S. Immigration and Customs Enforcement, they call themselves ICE. That sounds better than ICE. They wear the blue jackets, and it's just ICE across the back, like it's FBI, and they macho guys. And they're the people that do internal enforcement of customs and immigration issues. They're the ones that engage in worksite raids to round up undocumented workers, things like that. But you have all these other agencies. You have the Department of State that has jurisdiction over the embassies where people apply for visas abroad. You have the Department of Labor that gets involved if there's an employer sponsoring somebody for permanent residence. So just getting a handle on the multiplicity of agencies is tough enough, even with a lawyer. I've been doing this for 20 years and it keeps changing. I can't even keep on top of it. Then the sources of law themselves are so numerous and they're really hard to access. We do have one statute, the Immigration and Nationality Act, and I know nothing about tax law, but I've always heard that immigration is second only to tax in terms of its sheer opacity and complexity. I think that's probably right. But then you have the associated regulations, you have all sorts of formal and informal policy memoranda and cables and FAQs and Q&As and every kind of acronym you can think of that is the way you really know what the agencies are going to do and how they're implementing the law. They don't disclose all of those publicly. They post some of them on public websites, some don't. Some you only can get access to if you're a lawyer and you're a member of the American Immigration Lawyers Association and they put it on their website. It's crazy stuff. And then we have all these administrative agencies that get involved before you would ever even be able to get into court as an immigrant to appeal some kind of decision against you. The Board of Immigration Appeals, which is where you would appeal a removal proceeding, a removal order. BALCO, the Board of Alien Labor Certification Appeals, is where somebody, an employer whose sponsorship is denied would appeal a denial. The Administrative Appeals Office, that's where you go to appeal a denial of a family-based or an employment-based petition. For this reason, there's even a market for a huge array of secondary sources, including some of the books that I write that nobody can afford. So immigration is different for all these reasons. It's also different because, as I alluded to before, we're dealing with a uniquely vulnerable population. And there are people out there that are going to take advantage of opportunities to defraud immigrants. And especially in the context of comprehensive immigration reform, we have 11 million people, it could be more, right? We don't know how many people we're really talking about, coming forward to apply for whatever kind of legal status Congress sees fit to create. Nobody's really thought about the implementation of that. The idea is, yes, we're not going to engage in mass deportations. We're going to give people some kind of path to permanent residence and hopefully citizenship. But people aren't thinking about, as a practical matter, how do we implement that? And back in 1986, the last time we had a really sweeping, comprehensive immigration reform law, there were a lot of problems. There are lawsuits that are still pretty much going on now because of people that were denied the ability to apply the way they should have. In May of 2012, the Legal Action Center of the American Immigration Council, together with the Center for Immigrants' Rights from Penn State University's Dickinson School of Law, issued a really groundbreaking report called Behind Closed Doors, an overview of DHS restrictions on access to counsel. So that privilege to have counsel at no expense to the government, it doesn't just apply in removal proceedings, it also applies in administrative proceedings. But what this report uncovered, again, something we all knew who've been in this field intuitively or from practical experience, is that the 3 DHS agencies almost routinely engage in various practices to bar access to counsel. This is assuming you have counsel. We're not going to get into if you can afford it, where you find it, if you have it, but literally barring the door to people's lawyers sometimes who are showing up for visa interviews or who are being questioned in worksite enforcement actions or what have you. A lot of practices that you would really be surprised to hear about. They, through a FOIA request, got some documents from USCIS, which of the 3 agencies has been the most amenable to facilitating access to counsel. And even in those documents, you could tell by what they were telling their officers not to do what was in fact happening. Like, don't make the lawyer sit behind the client. They're allowed to sit next to the client when they're in your office and come in for an interview. If lawyers are being belligerent, it might be because they're actually trying to get a point across. And then there are all sorts of rules for how long you let the lawyer talk and when you cut them off and when you make them leave the room. I mean, it's just incredible. We've talked a lot today about the various kinds of empirical evidence that we need to address the immigration representation crisis, and I think the cost to society of the lack of representation have got to be vast, not just the cost of detention, the backlogs in immigration court. Maurice cited the figure that the average detention stay is 504 days. Yeah, that means that a lot of those are because of continuances, because people are showing up in court without counsel, and the judges are rightfully granted continuances so they can find lawyers. They don't always find lawyers, sometimes they come back still without lawyers or representatives. If everybody were represented, you've got to think that backlog would break down. But there's other costs to society as well. When you break up families, what happens to those people that are left behind, many of whom are U.S. citizens or lawful permanent residents? We're talking about the foster care system, which has to take in the children that are left behind. Food stamps, Medicaid, all those kinds of public benefits that U.S. citizens are entitled to. Those family members are basically often left on the public dole when the wage-earning immigrant family member is deported. And just the support networks in the community that have to step in when there are no government programs because you don't have a good enough safety net even for citizens, obviously, in this country. So basically, you've got the complexity of the governing law, you have the opacity and multiplicity of the government agencies involved that people, even with counsel, have trouble navigating, the cost to society when families are torn apart. All of these call for counsel or good legal representation of one kind or another, not just in immigration court, but I argue also in every encounter with the Department of Homeland Security, any kind of immigration administrative proceeding. As a practical matter, it does always come back to the funding. So I can sit here and keep talking until I'm blue in the face about why there should be appointed counsel and why the government should fund it. Are we going to see that? Unlikely. But there are some hopeful signs. For example, in the Obama administration's leaked draft bill for comprehensive immigration reform, there are provisions that would allow immigration judges to appoint counsel for children in some cases, and for respondents who judges deem to be mentally incompetent. The bar is still way too high, for example, even for the mentally incompetent, where it would be mandatory for the immigration judge to appoint counsel. It would only be mandatory if the IJ either didn't terminate proceedings because it was so fundamentally unfair to proceed otherwise. I guess that was it. It had to either terminate proceedings or appoint counsel, but only if the person is so mentally incompetent that it would be fundamentally unfair to continue. But I've not seen any kind of mandatory appointed counsel in immigration legislation that I can remember, so that's something, just that it's being thought of at the highest levels of government. That would be funded by some of the penalty fees that applicants for lawful status under the immigration reform bill would pay. So that's one way to fund it. Of course, you're talking about people that don't have a lot of money that are going to have to pay back taxes and application fees and penalties, and I mean, that's an issue in itself, but it is a potential way of creating a funding stream. Judge Katzman, who chairs this study group that I'm a part of in New York City, and I don't know if you know who Judge Katzman is from the Second Circuit, he's made it his mission to improve the adequacy and accessibility of counsel to immigrants. From his point of view, in a federal appellate court, he's seen so many cases where it was pretty clear that if the person had adequate representation earlier on in the process, they wouldn't be there, or they would prevail. So and the Second Circuit's docket is something like 40% immigration cases. It's insane. They even have a whole, I was a pro se law clerk in the Second Circuit years ago, and we had a fair percentage of our cases that were immigration at that time. They now have an entire immigration staff attorney's office at the Second Circuit just to deal with the immigration docket at the Second Circuit. He has recently proposed the creation of a national immigration lawyers corps, something like Peace Corps or an AmeriCorps Vista program in the United States, where you would pair up recent law graduates and deploy, I think he's suggesting 50 graduates every 2 months across the country that you would pair with retired or other senior immigration lawyers who would advise them. And then you send these young new lawyers out across the country to work with various nonprofit groups who would then hopefully be certified through the Board of Immigration Appeals to provide non-lawyers. The problem with the BIA system as it exists now is that there aren't enough lawyers supervising these accredited reps. So a lot of them are good at what they do, but there aren't enough of them, and there isn't enough supervision, and there just aren't enough mechanisms for them to have someone to go to do the research, to do the sophisticated analysis that's often involved. So a National Immigration Law Corps that you could also fund through some of the income stream coming in through the applications in an immigration reform bill is also a possibility. I certainly think that the government should restore funding to the Legal Services Corporation and in fact mandate that any group that gets that kind of funding must provide legal advice. Right now, LFC-funded organizations can't give legal advice to undocumented immigrants in any kind of proceeding, so that's a big problem. So yeah, it's a pipe dream. I understand that. But you know, I do have this pipe dream that that we would live in an America where nobody would be deported, banished, exiled from their loved ones without at least having a meaningful opportunity to challenge such drastic action being taken against them. And I certainly would dream that a Congress that is about to enact a path to citizenship for 11 million plus undocumented immigrants would not let short-sighted political infighting or even a fiscal crisis allow a situation to arise where we are creating a pool of people who are ripe for fraud and exploitation. So I hope we'll see that in my lifetime, maybe in yours. Thank you.
Thank you so much to our panel. I think we have 5 minutes. We have 5 minutes for questions. Anyone have any questions? Yes.
This is the kind of question I'm a little uncomfortable asking because it may be my hearing and not what you said. But this morning I heard it said that there are 5 times as many people who are successful with a lawyer as without a lawyer in terms of the immigration process. And this time I heard you say 500.
Yeah, I did say 500.
And I'd like to know, and maybe you're talking with different populations, but that's a big difference.
I was talking about a particular study that was done in New York on a
It is
slice of the
500?
population where if you were represented and non-detained versus being detained and not represented, it was 500 times.
Oh, detained, okay.
But still, even if you were not detained, I think only 13% of people who were not represented were successful versus 75, 74% of people who were not detained. It's a huge difference.
So this is more of a comment, but I'm interested in your thoughts. I actually have a more optimistic view as to Congress providing appointed counsel to immigrants, at least detainees, although it's ironically based on Americans' traditionally less optimistic view of immigrants. So I wonder, because Americans generally associate appointed counsel with criminal defendants who right to a lawyer, right to exile, and many Americans already associate immigrants as criminals, regrettably, I'm not sure appointed counsel to detained immigrants would cause an uproar. I wonder if, regrettably, it would just confirm the perceived criminality of immigrant detainees. You know, anecdotally, I run into people, you know, when I say, oh, I'm working on a project to give detained immigrants counsel, they say, oh, you mean they don't have it? And the other thing, too, is, you know, Congress statutorily provides appointed counsel to pretty much every other unpopular group that it locks up without a criminal conviction. So criminal pretrial detainees, post-conviction civil commitment of sex offenders, Al-Qaeda suspects now in the recent preventative detention law. Now that said, when Congress gave them all appointed counsel, most of those were, we're going to lock them up, and by the way, they'll get counsel, rather than we already locked them up and now we're giving them counsel. You know, it wasn't in the context of adding something. But I do wonder, you know, if the government, in these negotiations that are going to happen as to immigration reform, you know, in the past the government has valued the substantive ability to lock people up more than giving people process. And that may raise broader questions as to what we, meaning advocates, want to accept in immigration reform.
So my non-idealist self has several responses. One is I would expect the system to go towards other types of detention rather than physical detention, so ankle bracelets and other monitoring systems that, oh, look, they're not detained, now we don't have to give them counsel. So that's one, which is why I tried not to limit my discussion to detained immigrants, because I think when you do that, there's easy workarounds. Two, even if I shared your optimism about statutory mandate for appointed counsel, I have no optimism for funding that mandate. And recent experience, even at the state level, is that it's real easy to say so-and-so is entitled to counsel, and it's quite another thing to actually fund it. And judges are reluctant to appoint counsel when there's nobody to pay for the counsel, even if the statute says that that's what they're supposed to do. And I think that was 2. I had 31 and now I don't remember. But anyways, those are my initial responses. But that's like ultimately, admittedly, that's my non-idealist response.
So we want to make criminal aliens look really, really scary, and then maybe you'll get counsel.
Well, that was the other response, is that fundamentally I think American populace views criminal aliens as different than criminal citizens.
It's worse.
They're not even supposed to be here, right? That's the, why should we pay for counsel for folks who are criminally here in the first place? And because a lot of folks that I've talked to are surprised that it's a civil proceeding to begin with, that being in the country, quote, illegally is actually a civil distinction. It's not, that in and of itself is not a crime. That comes to surprise as to most folks. And so when you think about it in that context, most folks think it's double criminality, right? You're here illegally and you've committed a crime, so why would we give you representation for that? Certainly, why would we pay for it?
I think we're out of time.
Yeah, we should probably.
So thank you once again to the panel.